We will have it tomorrow. We'll see the video on video what has transpired on that day. Tomorrow it will come tomorrow. This is matter tomorrow. Anita, this 9/6/2025. That whatever is the footage, this video, this thing. Tell Mega with regard to this case. Yes, 2025. Look at that order. This is matter tomorrow. Learn senior counsel appearing for the petitioner submits that on the last occasion, according to the learned counsel, the respondent, this court had adjourned this matter only for the purpose of finding out. Please wait. Please wait. Yes. Before that, what did I say? And according to the learned counsel for the respondent, on the last occasion, respondent mother, this court wanted to dispose of the matter wherein the visitation was fixed during the course of the, it was agreed that the visitation would be during the course of the day, and the IA for maintenance will be filed by the mother, and there would be a direction by this court to dispose of the IA. And with regard to the counselor, the matter is adjourned to today for getting instructions. Then a senior counsel submits that there was no such understanding with regard to disposal of the matter. Only it is adjourned for what has transpired on that day is not recorded in the order sheet, in the proceeding sheet. And as far as this court remembers, it was agreed that the matter would be disposed of. This is matter tomorrow, so that the court would look at the video recording and then we'll understand what has transpired on that day. Yes, tomorrow. Yes, give the report. No, let me just see. It's an elaborate report. The registrar usually directs to a copy of this report to both the councils. This is matter day after. It's an elaborate report. They have discussed everything. Day after. Yes. Hmm? He has already shown to the court, but the court do not want him to place it on record. That is not in the interest of the wife. If you want it, they will place it. We will speak. We'll talk to your client. Let her come to the chamber. 1 o'clock. Yes. Yes. Next. Yes. It's submitted. The needful is done. Interim order earlier granted is extended to the next date of hearing. List after service of notice. Next.
My lords, I am appearing for the petitioner, my lords.
Yes.
I may be permitted to take fresh steps ascertaining the fresh address, my lords, since this is the address which was given
A
in the
week's
cost
time is
title.
granted. 2 weeks time is granted for
Interim order
taking
may
steps.
kindly be extended, my lords.
Interim order earlier granted is extended. 2024 interim
Great.
order we are extending in 2025 without any notice to the respondents.
No,
Yes.
address mentioned in the cost title
No, for
is
that
same.
it is taking a year's time. That's a difficulty.
No, I will
Yes.
ascertain, my lords. Grateful, my lords.
Non-compliance of office objections. What are they? No, that is second one. Hmm. Give that. What is the office note? Non-compliance raised at scrutiny stage. Non-compliance of office objections raised at scrutiny stage. Rectification of office objections raised on IA 1 of 25 for vacating stay. There are two objections. Copy is served, he served the vacate stay on you. Hmm. What is the writ petition about? How much was granted by the trial court? 50. What is the interim order of this court? Give that. Give the order sheet. The learned counsel. Then counsel for the petitioner files a memo for having paid a sum of rupee 2 lakhs by way of checks to the respondent, which has been withdrawn by the respondent pursuant to the impugned order passed by the family court. Is ready and willing to bear the educational expenses of 50% along with the respondent for both the minor children. He has not paid the. No, have you furnished the details? Okay, let's not go into all that. Whatever are the details, the bank details, the amount, 50% of the amount comes to what is the fees, what is 50% of it pertaining to both the children. Give those particulars to her today, and she has to. You have to comply it. What was the due? What is the due date? So by Monday, anyway, by Monday you pay. they'll furnish you the details. 50% of the fees.
Yes. And one more request, my lord, she's not bringing the children. There is an order of visitation rights. She doesn't.
No, everything you want in this writ petition to be decided.
Not only that.
No, it's only with regard to the maintenance. If she is not doing something as per the order of the court, which is not impugned before this court, you have your remedies, sir. Everything the High Court will not interfere.
No, that's what my lord, that he has been paying the school fee regularly till last year.
You have an order?
He has.
You have an order by the family court? From the family court, you have an order with regard to visitation?
Yes.
Then you please execute that order.
No, my lord, she doesn't. She doesn't bring, my lord, and she demands taxi fare, and she makes one or the other grievance, and she doesn't bring.
So you have one order that is not implemented. You want another order to be passed by the court. That will also be not, for example, if it is not implemented, how would you get it executed?
He's already paid 2 lakhs, and he's paying the EMI.
This court on 3/4/2025 has passed an interim order, having observed, passed interim order, considering the submission made by the learned counsel that already an amount of rupees 2 lakh is paid, and that the petitioner father is ready and willing to bear the educational expenses of 50% of the educational expenses of both the children. A vacate stay petition is filed by the mother. It is stated that the father has not paid the educational expenses, which is not denied by the land council appearing for the father. It is submitted that the details are not furnished. It is further submitted that in spite of an order of, why you are not complying with the order?
I am ready to comply for 30,000 for the first child, sorry, 34,000 for the first child. Now here, that itself they are not complying.
That's why you are not talking about.
The petitioner is earning about 15% of the salary also he doesn't want to pay as far as the maintenance is concerned. The only grievance is that I'm paying the EMI of the house is what they say. 50% of the EMI is also borne by me, where I'm staying. And right now, currently, the difficulty is that for the last 2-3 months, I've lost my job. I'm searching for another job also, just to make ends meet. My request is let me want to fulfill that order. It's a reasonable order. I'm not asking maintenance for myself. I'm gainfully employed.
How much is your income?
My income, admittedly, as far as my assets is concerned, for 2 lakh rupees.
2 lakh rupees is your income. What is your income?
3 lakhs.
3 lakhs.
And I'm paying EMI, my lord, which is coming up to 2 lakhs.
EMI of what?
EMI of the house where she's residing. I have been thrown out of the house. No, one, yes, I've been thrown out of the house. She's residing in the house with the children. Half of the EMI, both of them are sharing her, the EMI is sharing. But their EMI is coming up to almost 40 lakhs, 40,000 per month. And she's using a car for which completely the husband is paying the EMI for that car. And there is a house in Pune, my lord, which is a joint name, and the husband is paying the entire EMI to that Pune house. And he is also paying the maintenance charges. Now he has been thrown out of the house. He is residing in a rented premises. So all these expenses, my lord, will come easily up to 2 lakhs. But I have stated in a statement of objection. When this is the situation, the learned trial judge has ordered me to pay 50,000. If that is the case, what is the future of my children, my lord? And I'm ready for divorce. Even that she doesn't come up for settlement talks. She just wants to torture me by filing applications after applications. She's filed an application for amendment of the petition. So this is her attitude. I've been thrown out of the house. I am paying the EMI. I'm taking care of
Remove all that, whatever written. Then counsel for the petitioner husband submits that the EMIs and the other the EMI for the car, for the house, and for a house at Pune, all that she's paying an amount. The husband is paying an amount of rupees 2 lakhs, and he is ready to take. He is ready to pay 50% of the educational expenses of both the children. The husband's income is 3 lakhs and the wife's income is 2 lakhs. It is submitted that in the house in which the wife is residing and from where he has been thrown out, even that EMI, part of the EMI is paid by him. It is submitted that in spite of all this, though there is an order with the family court giving visitation to the father, he was not able to, he could not see the children as the mother is not getting them. Visitation center is one.
Visitation is ordered, she's bringing them to the family.
To the
court.
visitation
On
center.
probation, she has brought the children also.
When is the visitation next?
First and third Saturdays, Mother.
Third Saturday is coming Saturday. Coming Saturday.
My lord, I don't want to make it. She demands taxi fare charges. I mean, she's earning 2 lakhs, my lord. She's staying in a house where the EMI is being paid, and she makes.
List this matter on Monday, basing on the visitation on Saturday. Further orders will be passed.
He was not thrown out of the house. He has himself voluntarily.
According to the learned counsel appearing for the respondent, mother, he himself has left the house, and the allegation that he has been thrown out is not correct. When the court passes an order of maintenance, and when the court also passes an order of visitation, the party cannot be expected to fulfill or comply with the order which is acceptable to them, and the other order they cannot say they can't afford to not comply with the same. This matter on Monday, basing on file it in the section. Yes,
My lord, and regarding the objection, my lord, the others I will try to come in copy.
within a week, that also. Yes, next.
My lord, it is 7 office copies. So
For
let
that,
me
what you're supposed to do is, there should be a submission from your side why you're not able to comply. Then we will see next week. What is this report of the? Uh, 1 minute, 1 minute. What is the prayer? What are all these prayers? What are all? How many prayers? No, can you maintain these many prayers in one petition? One I understand. When you asking for dispose of the matter, what about the other? Now we can only number 2 we can order.
That may be ordered, not the other incumbency for me that I want to visit the child. My application is of year 2023.
That's what we do is we cannot tell the court to dispose of the main MC of 2023 itself. Now the IA that's pending both for the interim custody as well as the visitation custody with oblique visitation and also the maintenance filed by her, both shall be disposed of within 2 months from today. You kept it is happening from 23. No urgency for the court now to pass.
Now, Lord, I have made an allegation that my wife is fallen with the paramount, is so with the paramount. Now the child is now being taught that the paramount is the actual biological mother of the child. There is some urgency in all that I requested.
No, that's what the court is going to dispose it of in 2 months. There can't be any order, particularly with regard to the child. Just like that, an order can't be passed.
In 2 months, the application will be decided at board of the family. However, the interim of these 2 months are on very permission to meet this child. That's all I'm asking for. I think that should be every Saturday, Sunday, at least 2 times in a month.
That is what is the interim application for. No, whenever you file an application, that court will decide and it will once for all be done. What is not happening from 23, just there can't be any urgency for the just 2 months. All this you can raise before the court. Now, this with all these kind of applications and all these reliefs, the court is also burdened with so many applications there before the court. Please come. Yes, the writ petition is filed seeking the following prayers. Then counsel for the petitioner submits that the application seeking visitation, custody, oblique custody is filed in the year 2023. Till now, no orders are passed. This court has called for a report from the court why an application for visitation is not disposed of by the court. A report is placed before the court by the learned judge stating that that the judge has assumed charge recently and giving several reasons. All those reasons this court cannot appreciate. It has been in several cases, this court has passed orders directing the family courts to dispose of the IAs for the IA for maintenance, interim maintenance, and IA for visitation expeditiously. And in the review meetings also, it is brought to the notice of the court that they are disposing of the matters within 1 month. But the proceedings, how it has taken place in this case, right from 2023 till now, these kind of delays will further aggravate the differences and problems between the parties. If within a time frame, if any of the party is not filing objections or any application from their side, that's not the concern of the court, but still the court has to pass orders. Now it appears that there are two applications. One is IA for maintenance and one is IA for interim custody oblique visitation of the child. Both these applications shall be disposed of within a period of 1 month from the date of receipt of the copy of the order. Next, as disposal of this court is not proposing to issue notice to the respondent, as disposal of the case is in the interest of both the parties. Huh? No, it's a family court, Bangalore. There are matters of, it can't be. There are several matters. Why should we give it a special treatment? Yes, it's supposed to. Huh? Notice 11. Notice. It will be issued if you wait till 491 days. No apologies. When you do not comply with the order, when an order is passed and wait till 491 days, come to the court and seek interim order, how is it right? And why should the courts, pass an order?
He's an assistant to VP He's working on a week basis. He's not stating it will be not paid. Sometimes
What are you doing till 491 days? That I want to know first. No, you should have filed a condone delay petition. And then you must have stated the reasons. What are the reasons? No, as a matter of right, nobody can come to the court whenever they want, when there is a limitation. Please come to that affidavit. Yes. Submit filed the next the subject I could not meet my lawyer as is not at the best of my health. What is his age? Age 45 years. What is his ailment which made him not to come to the court?
But he was paying maintenance. I'm not denying that. He's paid the education fee as
No, what will happen is, if in this manner, if the High Court starts interfering with every order, what is the sanctity of the family court and why the family court should pass any order? Anyhow, whatever order that is passed, for every order you come to the High Court, you in the sense, client will come to the High Court will stay the order, just like that. When the litigant is not vigilant and we doesn't even give proper reasons for the delay, why should the court pass an interim order? We cannot. It sends a very bad message. No, what every litigant thinks is let family court pass any order. We will go to the High Court when the warrants are issued, and the court will just like that. It's a thoroughfare. It will pass an order, and even no for even filing a condone delay petition also nothing. No, when 450 more than a year, 1 year, 3 months or 4 months is a delay, and you don't and when it is when it says in this kind of an ordinary delay, each and every day's delay has to be explained. Simple. I couldn't meet my advocate. Who stopped them from meeting the advocate? And you say, I'm not feeling ill. What you are not feeling well? A non-delay petition should contain.
barriers that are pending as of today, about 5 lakhs. He's admittedly here, the trial court has ended 28. He might claim that he's earning 40,000, but she is not able to prove.
But Mr. Gautam, again, we come back to the same point.
I don't.
But this is not the way. We shouldn't, High Court should never entertain these kind of petitions. There should be some discipline.
I'm trying to deposit the areas because
Entire areas to be deposited. Then no 50%.
please,
All this revision is filed with a delay of 491 days. Court had granted maintenance of 10,000 from the date of filing of the petition. The reasons for the delay of 491 days are not convincing to the court. Are not convincing to the court. In these circumstances, the request of the counsel that he will pay 50% of the amount, this court is not able to, this court is not inclined to consider. However, if he is ready to pay the entire arrears as on today, within 4 weeks from today, on that condition, there shall be stay of all further proceedings. No further time will be granted. And if within 4 weeks, if he fails to pay the amount, the wife is at liberty to execute the order. Huh? That's what the warrant so and so is state, and within 4 weeks from today, if the amount is not paid, the warrants will again will come into effect. Yes.
My lords, the respondent is represented by the advocate. So IA number 1 of 25 may not
Already
be.
notice to the respondent is served and represented by advocate, and no orders are required on IA number 1 of 25. What is this matter about?
My lords, I'm challenging the order passed by the trial court where I filed an IA to direct the husband to produce his recent salary slip.
There is a stay in this.
No, my lords, no. If they file their objections, it may be taken up on next week.
What is the impugned order? Where is the impugned order? Page number? Oh. So you didn't sought for any permanent alimony in this case.
I have consented for the divorce, and in order to claim my alimony, my lords, the recent
There should be
salary
an
slip,
application for that.
that they should only produce, my lords. I am not available with the,
What alimony application?
not my lords, this salary slip to, in order to calculate.
Oh, please read the order and tell the court what is wrong with it. Even if there is no application while granting divorce, why can't the court decide about the permanent alimony? That I understand. Look at the order. The question I'm asking is not that. That I understand. That criminal miscellaneous, they have an order of maintenance. Now, in this case, with regard to the permanent alimony, what is the difficulty to you? No, while deciding the divorce, court will not grant permanent alimony. Please come. The agreed with orders passed in I number 19, in I number 7 under section 151 CPC, whereby the wife had sought for a direction to the husband to furnish the latest salary certificate, and the same came to be dismissed. Agreed with thereby, the wife is before this court. The order impugned reveals that already in a criminal miscellaneous court had granted 1,75,000 towards interim maintenance, and in the MC, no application is pending for the maintenance. And with regard to permanent alimony also, no direction is sought. In those circumstances, the court has observed that if the wife seek permanent alimony, then they are at liberty to file the fresh IA seeking the relevant documents connecting with their prayer, and accordingly the same is dismissed. Then comes for the petitioner, wife submits that the court, without considering any of the aspects, had dismissed the petition. And the salary slip of the husband is very much required in the facts and circumstances where the wife, while granting permanent alimony to the wife, land counsel appearing for the respondent husband submits that without there being an application, and what is the relevancy of the salary slip? The latest salary slip is not stated. It is submitted that only to drag on these proceedings. These kind of applications are filed. Next, for having heard the counsels on either side, there is a material on record. Admittedly, there is no IA for interim maintenance, or there is no IA for the there is no prayer for the permanent alimony. Then, in that case, what is the relevancy of the the seeking seeking a direction to the husband to furnish the latest salary certificate is not known. Even in this order, the court had given liberty to the petitioner, stating that if they seek permanent alimony, they are at liberty to file the fresh IA seeking the relevant documents. This court is not able to understand how the petitioner is aggrieved by this order. As pointed out by the counsel for the respondent, it appears that only for the purpose of dragging on the proceedings, these kind of applications are filed. Accordingly, hence this court finds no reasons to interfere. Dismissed. Yes. Pass over not possible. This is matter on Thursday. Yes.
Appearing for the
What
petitioner,
is this recalling application?
my lords, matter was dismissed for non-prosecution, my lords.
If you don't appear, what will happen?
That's it.
At least court must have dismissed it, giving you an opportunity of 2 times.
No, that's it was dismissed on the first day itself, my lord.
On 5/6/2025, the matter was listed before the court for complaints. As there was no representation, this court had directed the matter to be listed under the caption for dismissal on 6/6. Today also there is no representation. What is the reason for this, for your recalling this order? Let us see.
My lords,
Let us see.
when the matter was called out, I was engaged in other court.
That is one day. Second day, read it, read your affidavit.
Para number 3, my lords. It is
You
stated
didn't
that
give any answer. What has happened prior to that?
my lords, I was not aware. Listed on 5/6.
How you cannot be? How can you say that you're not aware? Is it an excuse?
No, my lords.
What you, when you know that matter is listed on 6/6, why you are not aware that it is not listed on 5/6? The IA is filed, seeking to recall the order dated.
From now on, I'll take.
Huh?
From now on, I'll not.
Huh?
From now on, I'll make sure
The
that
order
matter is not
dated.
taken.
6 June 2025, whereby this court had dismissed the petition for non-prosecution. In the order, the court has observed that on 5/6/2025, the matter was listed before the court for complaints of office objections, and there was no representation on behalf of the petitioner. This court had directed the matter to be listed on the caption for dismissal on 6/6/2025. Again on 6/6/25 also, there is no representation on behalf of the petitioner, as the matter is dismissed for non-prosecution. Then counsel for the petitioner submits that on 6/6, he was engaged in the other court. If he is engaged in the other court, after the matter is dismissed, he would have taken steps to come before this court and make a mention. That was not done. Then even what has happened on 5/6/2025, why he was not present before the court, also no reasons are stated. Just like that, when there is no representation on 2 occasions, when no explanation is for convincing explanation is forthcoming, just like that, this court is not inclined to recall the order. However, considering the substantial interest of the parties, the order dated 6 June 2025 is recalled on the condition that the petitioner shall pay an amount of rupees 1,000 to the Advocates Association within 1 week from today.
There are
Yes.
minor office objections. I'll complement. Let's kindly have it tomorrow.
Money and that you do it by tomorrow will come up.
But Wednesday, my lords.
This matter on Wednesday. If he complies with the office objections and the amount of 1,000 is paid to the Advocates Association. Yes, next.
Serial number 15, I appear for respondents counsel, my lord.
Lord,
Yes.
pray for time, Lord.
Right.
2 days time. Senior is
Interim
close.
order is there.
No, Lord.
Interim order is there, Mr. Counsel.
No, my lord, it has come for IA actually. There is no interim order.
This is matter after 2 weeks at the request
Lord,
of.
Wednesday, man.
It can't come whenever you
Lord,
want.
see-
List this matter next week at the request of land counsel for the petitioner.
Obliged.
Of an application filed under 26th of Hindu Marriage Act, Lords, whereby the respondent wife, who is in custody of a 13-year-old boy, sought for directions of the Honorable Court, learned court, directing father to come along with the child for parent-teachers meeting. Depression, the child is getting treatment for depression because of he not visiting the child. He has had a visitation rights order got for him, but
What is impugned order? Let us see.
impugned order is that, minutes, what only at page number, I beg. Looks 61 minutes. 61. IF
IA number
15.
59 is IA under 24.
15 minutes at page 61 minutes. Plus the respondent filed IA under 26 of Hindu Marriage Act, seeking issuing certain directions to petitioner, her husband. In this case, in this IA, the petitioner and his wife sought for directions to respond to meet his son.
Where do you get that? I'm not able to see that.
This is petition number 1449, my lords.
Yes,
Please.
page number 60.
61, my lords. Ink page number 61. A series of IAs were disposed, my lords, by a common order, dated order. My lords, get it?
Yes.
First, I would like to submit, make preliminary objection, also submission that the writ petition was on the order of union order of IA number 15. IA number 15 order has been passed on 14 to 2025. This writ petition has been filed on 25 for 2025. There is a clear delay of 7 days, and this writ petition is barred by the conviction under the Family Court Act section. So I beg to this court to dismiss this writ petition on this first submission. Second submission I want to make, my lord, that this IA that has been filed in this multiple relief has been sought by the petitioner.
What do you say about this IA, this relief will not go to the other things?
This IA, she has asked the family court to direct the father to act and behave in a certain manner. Like father should meet the child in presence of the mother. Father should organize the.
No, without going into the conditions, what is the difficulty of the father to meet the child?
I am ready to meet the child. The problem is, and I have requested multiple times. Order for meeting the child had been passed in 2019, and this is a clear case of child alienation, wherein the mother has taken the child to Gaya for around 2 years. Then again, I asked family court to reinforce its order. It reinforced the order. Still, the mother did not allow me to meet the child. Finally.
So point number one is you are ready to meet the child. Then now you can go to the parent teachers meeting also.
Yeah, but I don't want to go together with.
You can go independently.
Yeah, I am ready to go independently. I am ready to celebrate his birthday independently. I am ready to meet him as and when he wants. So I am ready to do everything for my child because he is my son and I am ready to do everything.
Yes. If your interest is only about the child, he is ready to do. You can't compel him to do something along with her. Now we will record that he is ready to go to the school. He is ready to meet the child. He is ready to celebrate his birthday.
Please.
He will celebrate it on his own, not along with the mother. If it is that can the
if I may submit.
1 minute.
If I may submit. Lords, this marriage has begot 2 children. First child is born in 2000. He is already settled, such elder child. And second child is 13 years. Now there is a brotherhood as well in the family. And they have lived, and since 2017 they are separate, my lords.
Whatever it is, you
Lords,
cannot.
my submission is this.
This is an MC.
Yes,
in a MC. How can you seek? And now, considering the child's interest, when the father is ready to do all these things, you can't compel them how you want.
May I request, my lords?
Yes.
One thing. I have narrated in affidavit all the circumstances of me taking the child to the doctor for depression treatment. We want the father to accompany along with the child to the doctor as well. Doctor's name is there, prescriptions are there, dates of visits are there. My lords, all these things have been on factual, on facts. My lords, only on the ground of maintainability, my application is turned down without even applying mind on these factual
Even
aspects.
at this point of time, when he is ready, you're
Yes,
coming with the
No,
I will record
PTM,
all that.
not just PTM
That-
minutes.
No,
May I
no,
take your
one,
lordships?
1 minute.
What?
No, parent first, you will be, when he can visit the child,
Please.
when he can visit the child, how he will visit the child.
Lords, as per the visitation rights, whatever the family court has granted, my lords,
What
I'm-
are the visitation rights? Every alternative Sunday. What is the age?
age is 15 years. No.
Why 2 hours? When you are so much interested that the father should meet the child, why 2 hours?
Not at all, my lord. He can increase, he sought for, he is agreeing, he is happy with those 2 hours. Thereafter also, he did not come to meet, my lords. No, my lords.
What is?
Whatever he wants.
How is it comfortable to you? The
Therefore-
maintenance, I mean, the visitation.
I'm comfortable with the alternate Sunday 2 hours. First, let us start with that because he has not met you for last 8 years.
8 years.
Yeah. So he has not been, because he has not been letting him meet. Then High Court of Karnataka had also compelled her to let the child to meet. She took him to the doctor and he was frozen in front of her psychiatrist. And psychiatrist said that he is having depression. And psychiatrist suggested to take him to Liman. She did not take that because Liman has the technology and also has the process to find out.
So alternative Sunday, 2 hours, where? Where is it comfortable to you?
Order was that near the lobby of the flat where she is staying, and I'm ready to meet near the lobby.
So as far as the visitation is concerned, as per the order dated, what is the order dated?
Please.
Order dated.
Order has been dated in 2029, in June.
2019.
In June.
Date.
Date is,
Look at the order and tell.
28th of June 2019.
28 June 2019 is the order. So as per that order, you are ready to have the visitation, number one. Number two, you are ready to go to the school independently.
I'm ready also to take him to doctor if it is so that he is sick. But I want to take him alone because I'm afraid of going with her. She has filed so many, 14 cases she has filed so far. And so many allegations which have not been proven. So I'm afraid to be with her.
14 cases, my lords, only 490.
So like these, on these three, will dispose of this petition.
My lords, may I submit? Only 2 concerns, my lords. My lords, the child is being treated for depression. Now, as per him, my lords, in 2019, there was a visitation rights ordered for him for 2 to 3 hours. The father, if at all she had stopped, my lords did not even bother to file any objection.
I already understand that this petition doesn't require any adjudication, but for his,
Please.
so let's not go into all that.
But the
Now,
point,
with all the
may I request my lords to take page 66, the certain of the requests, certain very specific requests that what we made to the family court, supporting to which there were materials placed. May I request your lordships, 66 minutes. So that if those specific things are
At least we
directed,
have to tell the client that these are all the things can't happen. Everything under the sun, she can't come, whatever her requirement, she can't come and ask the court.
we were not asked for the.
What is all this? Can there be a direction like this?
My lords,
In a petition filed by her for my divorce, can this court will pass all these orders against the father without his agreeing to this?
But he's agreeing. Para 4, I mean 67, 4, my lords. I have not sought for presence of the mother at all. Parent teachers meetings. No, my
Yes.
lords, there is a misconception of him.
Please read.
Please, in 66 minutes.
Yes.
To meet, first request is to pass orders for meeting son in presence of mother.
That is not acceptable to
Not
him.
acceptable. Please, minutes. That's second minutes to organize and attend Arush's birthday in November and May, and celebration happens twice a year at the very same home or other place, and to be attended by
This is
responsible.
also not possible. He will do it.
Minutes.
This also he will do it, not in her presence.
My lords, the child would like to have his friends, his relatives. My lords, there can be a condition on mother not to utter a word and stay at one distance. There can be. There can be.
Yes.
My lords,
I think we'll,
end of the day, my lords.
I can't hear it more than this. Please
My
understand.
lords, there.
Yes, next.
End of the day, my lords, the emotion of the child. That is
The
the.
court understands.
Please,
Court
my lords.
understands the
The
emotion
third
of
is
mother
that,
and
my
child
lords,
both.
please, my lords,
Yes.
attend the other social religious functions like so and so, along with the child. My lords, they are required for.
Presence of his mother. What is this?
My lords, presence of mother, my lords, social gatherings, my lords. PTM we have not asked, my lords. My lords, may kindly see the fourth point, my lords. Fourth part, my lords. Fourth part, make way. attend the parent teachers meeting, so and so, along with mother, so and so, along with, if he wants to meet all by himself to the teacher, my lords, we don't have any objections.
Next.
My lords. And to inquire about health of him with the pediatrician, medical consultants along with the mother, and herein, and required to inform either Arush himself or his mother, either inform Arush that the child himself, who has got a phone and he is interacting, either talk to him or mother, or we have sought for him, whatever he is agreeable for that. And next is to share all important informations like with the mother or grand.
I think, yes, please come. Agreed with orders passed in. I number 15, dated
Next.
14 to 2025.
Both are very, at one submission, both are very much learned, my lords. If they want to mediate and talk, my lords, even I would like to, I have come on record very recently.
14 to 2025. The 14 to 2025, the mother is before this court, along with several other IAs. I number 16 is filed.
15.
I number 15 is filed. I number 15 is filed, wherein she sought a slew of directions to the father, as many as
9 minutes.
9 directions. The court, by order impugned and dismissed said application, observing that the court cannot direct the father to do any act which are against his interest, and such type of directions on the say of one spouse, the court cannot direct the other spouse to act in certain manner, and accordingly dismissed it. Then counsel appearing for the mother submits that the boy is suffering with depression because of the disputes between the parents, and the father is not meeting the child, and also the birthday and the twice in the month of May and November, and also all other festivals shall be celebrated by the father along with the child in the presence of the father, in the presence of the mother. It is submitted that as in view of the long standing disputes between the parties, the matter can be referred to the mediation. Next, let counsel appearing for the party in person, respondent husband submits that he is ready to, he is very much interested in the welfare of the child. As per the order passed by the family court dated 28 June 2019, he is interested to exercise the visitation. It is submitted that he is ready to celebrate the birthday of the child as they were celebrating, that is 2 times in November and May. He is ready to go to the parent teachers meeting and to the doctor, and all the festivals also is ready to celebrate with the boy. But the mothers, he cannot have the mother's presence, as there are about 14 cases filed by the mother, and he do not want to, there are 14 cases between the parties.
No, 14 cases are not there, only 3 cases.
14 cases filed by the wife. And 3
He can
cases,
give the list, my lord. That's wrong.
That's his submission.
Please.
3 cases
And one more,
filed by him. Please,
only one submission.
no. 3 cases filed by him.
Fees is also due, my lords.
Huh?
Fees, school fees ordered to be paid by him on visitation, and he has not paid till now. And there is almost about
There is an order, court will take care of it.
Millards.
You can file an
ninth
execution.
prayer in this case, my lords, in this application, 9th prayer, is to meet the expenses of the child also. Because, my lords, delayed payment of fees is resulting also in one question on the child. Child is studying in one reputed school because both of them.
Mr. Counsel, you have to understand that.
Please.
Court is entertaining this application, though it cannot be entertained, and you cannot afford to make all these requests. So please leave it there.
Payment of-
And the client do not, if there is an order by the court, there is a way to implement it. It is not another application to be filed for implementation of it in an IA.
I concede. My,
The client do not
apologies.
understand, but
I-
advocate understand
My-
what is the scope of litigation. Yes, what did you write? File, and he is not ready to meet the, he is not ready to do any of the above in the presence of the wife. Next para. Heard the learned counsel for the petitioner as well as the learned counsel for the party in person. This court finds no conformity with the order passed by the family court. However, considering the fact that, considering the interest of the child and also the submission of the father that he is interested to meet the child, this court is disposing of the red petition with the disposing of the red petition accordingly the following order. 1. The father shall meet the child as per the order passed by the family court dated 28 June 2019. The father can appear, shall go for the parent teacher meeting independently. And 3, as he is ready to take the child to the doctor, basing on the requirement and after consultation with the boy, the father can take him to the doctor. Next, the fathers can celebrate the birthday in the month of November as well in the month of May, as per the choice of his place, and even on other festivals also, which is convenient to the boy and to the father, they can celebrate the festival. Accordingly, dispose of.
well, it's only once. Let him pay the school fees. School fees of the child, my lords, in the interest of the child.
Next. 17. What about 17?
17 is, my lords, with respect to her maintenance
IA
application.
number 1 of 25 is dispensed with, for the protection of original so and so. IA is allowed. Yes. Let's see where is the impugned order.
My lords, impugned order is at my lords, this is the order on IA number 11, my lords. Impugned order is at 27 minutes. 27.
Yes, already an IA is filed. That is disposed of.
My lords.
You have not questioned it.
We have mentioned.
Where have you questioned it?
We have not questioned. I thought
Then-
mentioned. We
then-
have not questioned.
And then in that case, court was right.
My lords, my.
You cannot come up with successive applications like
I
that.
have got only one ground, sir.
Yes.
This order is dated November 2018. My lords, then at the beginning of the proceedings, then she was trying to find her job. Immediately she had lost her job. And thereafterwards, my lord, she had made her efforts. Now there is a change of circumstances pleaded in the petition application. Affidavit has been placed.
What is the provision under the act which gives you, so the application for enhancement of the maintenance? Interim maintenance will not be decided every
My lords,
one weekend.
It is not enhancement, my lords. The application was given, order was granted only for the child. It was not for the
Then
petitioner.
that is dismissed.
That's dismissed.
If it is dismissed,
Please.
it has to be questioned before the court.
Please.
And without that, why would the court will review?
Lords,
its
we are
own
not
order?
on that. We are not at all on those applications. We are not repeated those aspects at all. No, my lords, I am on two different de novo facts, my lords. De novo facts are that, my lords. This is of the year 2018. No, my lords, the
The
Neha,
council, please understand, there is an order dismissing your IA for interim maintenance. Without questioning that order, whatever are the circumstances, can you file a fresh application is a simple query from the court. You please answer to that.
my lords, if there is change of circumstances, modifications, application can be filed, my lords, is my submission in view of a judgment of Honorable Apex Court.
Yes. Please
That
read
is
that.
already placed along with the
Yes,
petition.
where is that?
That is at page 50, my lords. Rajinish
Page
Sharma,
number?
page 50, my lords.
Where did it say?
This is,
Court has decided about your entitlement that you are not entitled.
please,
That's what it is.
please,
Oh.
please, my submission is that, my lords, that was decided way back in 18. Thereafter, at that juncture, and thereafterwards, change of circumstances were placed. Those aspects were not at all applied by mind. The court has not applied its mind to those
What,
aspects.
let us see your application.
Please, my lords,
Where is that?
please. At page 33, my lords.
Yes, read.
Annexure B, my lords. For the reasons stated, we sought for maintenance of 1,50,000 per month and a litigation
This
expense.
is, where is the earlier application?
Earlier application, my lords. I have not placed, my lords. I have not placed on record. That was also sought for both the child as well as the mother. Child was granted and the mother was not granted. My lords, in this, your lordships would find that in second paragraph itself, we have narrated that there has been an order only for the child, not for the mother. And the all change of circumstances have been narrated to. And my lords, my only grievance in this petition is that, my lords, the learned trial court did not at all apply its mind to these level facts, nor considered Rajinish Sharma's mandatory directions of Honorable Apex Court, sought for the, according to which the court should have sought for the assets and liabilities and decided the matter. My lords, assets and liabilities very clearly indicate what happened, earlier order and change of circumstances. All those aspects had to be considered by the trial court, my lords. That is the only grievance I have, my lords. Let there be a remand to the family court, my lords, to consider afresh in terms of Rajinish Sharma, nothing more.
As on that day, she was having job. As on that day, she was having job, and the court has held that she's not entitled.
Yeah, and then she claimed that she resigned the job. I think the next year only she filed the maintenance application. And then in that case, family court had asked us to produce the salary slips and I produced. She has worked for over 23 years, right from 1993. She has been working as an electronics and communication engineer, and also she has done MBA from one of the most premier institutes of the country. She was working as a business consultant. She had traveled and lived in abroad in the US, in Germany, and all those places. And then I had produced all those assets and information what she had.
That was earlier when the application was dismissed.
Yeah, so then family court took the documents of all the information assets, and family court has also recorded while passing the order that what she has and how she has resigned and how much qualified she is, etc. And based on that, family court said that
No. 1 minute. As on the day the order was passed, she was not working.
she was not working as on that. She claims that she was
Even as on that day also. Then what are the change circumstances now?
Lords, then immediately she had not stopped working because of taking care of the child. Then, my lords, my only submission is that.
Please listen to it. First I have to understand the facts.
Please.
I'm asking you, as on the day that application was dismissed, that day whether you are working or not, what is the order of the family court?
That day I was not working.
And then today also you are not working. What are the change circumstances?
My lords, it's more than 7 years, and now, my lords, Rajinish Sharma mandates that, my lords, there can be umpteen ways for a wife to.
Where is that order? You have a copy of the earlier order? Passed by the court? Yes, please pass on that. Take that.
My lords, the format of affidavit prescribed by Honorable Apex Court, my lords, would cover all these aspects.
That I know.
That's the only grievance, my lords. It should have been considered.
Let me look
Please,
at the earlier order passed.
Please, my lords.
you may see page number 9 and 10, all those things are recorded in the order.
It was not taken confirmation from me. After that, I was Recently resigned, so I had some saving. But now after 8 years, I don't have saving. I cannot loan. Son, I am retaining some.
I understood.
Yes.
One second.
Yes,
My lords, page 52 make
yes.
dictum of Honorable Apex Court.
Mm.
Page 52 minutes. This judgment, my lords, the date may kindly is that, my lords, November 4, 2020. By then, my lords, when that order was passed, this was not in play. Subsequently, this judgment came up, my lords. Page 52 may kindly. Modification or variation of previous order. Page 52 minutes. And before that, my lords, before page only, it starts, my lords, disclosure as to award of maintenance, any other proceedings mandatory. And if it is disclosed that it is not so, modification. My lords. If the order passed in the previous proceedings require any modification or variation, the party would be required to move to the court concerned in the previous proceedings. So, for the instance, once an order of permanent alimony in the HMA is passed, the same would be modified by the same court by exercising its power under section so and so, so and so. My lords, the modification power is very much vested, and no, my lords, change circumstances were pleaded in the application. My lords, the court had to apply its mind to the facts as well as this law, my lords, which prescribes that, my lords, at page 128, my lords, 114.
100
I beg pardon. Para 128 minutes. At page 128 minutes, Your Lordships. 129 paramount. Affidavit disclosure of assets and so shall be filed by both parties in maintenance proceedings, including pending proceedings before the family court, district court, so and so and so. Criteria and format, everything. My lords, this has been reiterated by Honorable Apex Court in again and again into a couple of matters. My only point is this, my lords. While this order, impugned order came to be passed, my lords, that was already in the application. It was narrated about the order that we have not suppressed the order of 4th November 2018. Subsequent to this, my lords, the change of circumstances that, my lords, she has placed on record. But the learned trial court dismisses my application only on the ground that earlier there was an order and therefore it need not consider the subsequent order. My lords, that per se, in the view of this judgment, my lords, is not. That's my
Agreed with orders passed in I number 11.
to consider assets and liabilities.
Dated 14 to 2025. Yes. I'm not convinced with what he said. 14 to 2025. In IA number.
In ground what respected counsel has mentioned in ground number 15, that entry maintenance award.
You know, we need not go into all.
Just
Order,
listen to this one, because it's a
not
why
required,
that they implement.
not
I
required.
have the passbook that I have paid all the maintenance till 14, and he has mentioned that I have not paid.
I'll record you, sir. Agreed with order passed in I number 11 in MC number 39941 of 2017, dated 14 to 2025, whereby an application filed under section 24 of the Hindu Marriage Act seeking maintenance pendent light is dismissed by the court. The wife is before this court. Earlier, the wife had filed IA number 4 under section 24 of the Hindu Marriage Act, and on 14/11/2018, the court had granted, she filed the application seeking maintenance for herself and the child. Court had granted maintenance uh, to the child at 20,000, and the application, as far as the wife is concerned, is dismissed. Dismissed. Learned counsel and the court observes that the in the light of the earlier order passed on the maintenance pendency light, once again has come up with the same relief. Therefore, that cannot be considered. Learned counsel appearing for the petitioner, relying on the judgment of the Honorable Apex Court in Rajneesh versus Neha, submits that in the changed circumstances, the party can always come up with the application, and the court is at liberty. Court has a power to pass orders enhancing the maintenance considering the facts and circumstances of the case. It is not that the court is it is not that court cannot consider the said application. He submits that the changed circumstances are that she has no job, she is not able to maintain herself, and she sought for filing of this petition. Next one, land counsel, party in person, husband submits that as per the order passed by the court, that is maintenance with regard to 20,000. You have paid up to date. He has paid up to date, and in the grounds it is stated that the husband is not paying, which is an incorrect submission before the court. It is submitted that when once the court had dismissed the application, considering all the facts, considering the educational qualification and 23 years of service she put in, now there are no changed circumstances, and the court had rightly dismissed the petition, and there are no grounds to interfere. Next para. Having heard the counsels on either side, peruse the material on record. Before going into the merits of the matter, it is appropriate to look at the application, that is I number 11 of 2022, that's filed by the wife seeking under section 24 of the under section 24 of the Hindu Marriage Act. In the application that is filed, it is stated that the court by order dated 14/11/2018 had allowed only one-time medication expenses of rupees 20,000. Within a short time after the wife has filed the case, after the husband has filed the case, in the year 2017 itself, she has lost the job due to stress and mental agony. Since she was unable to deliver work properly and was compelled to resign under the pressure of the company, a copy of the resignation is produced. And as she could not seek any other employment due to household responsibilities, and also she has required to take care of her minor son, whose custody has been given to is with her. Therefore, as she has no specific source of income to meet the living expenses and that of the minor son, and accordingly, she has come up with this application. It is also stated that she has filed a maintenance petition in Gaya under section 120 of CRPC. However, it is likely to take long time before any order is passed. Hence, and she is now staying at Bangalore and cannot pursue the matter at Gaya. As such, she sought for the maintenance. What is your salary?
My salary is around 2 lakhs.
it is stated that the husband is earning 10 lakhs per month and he has to take care of the expenses. And it is also appropriate to look at the earlier order passed by the court, wherein the court had dismissed the IA number 4 filed by the wife. In the said IA, the court records the finding with regard to the fact that the wife is not working. The court observes that both the parties are earning members, qualified persons, and capable of earning and maintaining themselves. As admitted by both the parties in the present application, the wife is not entitled for the maintenance only on the ground that the husband is having properties in his name. The wife is also having properties in her name and also having his own income, and that it shall not give right to the wife to claim maintenance from the husband when she is capable of earning and maintaining herself. And accordingly, the court had given a finding that the court had dismissed the application as far as wife is concerned. And as far as the husband, the daughter, the son, court had granted 20,000. It is a case of the husband that is earning is earning 2 lakhs. The learned counsel appearing for the petition has relied on the judgment of the Honorable Apex Court in Rashish versus Neha, wherein the Honorable Apex Court has observed that in the changed circumstances, successive applications can be filed and the court can appreciate the same. Here, as per the application filed, the changed circumstances is that she lost the job. But as on the date the earlier order is passed, even on that date also, she is not having a job. That was recorded by the court. In such case, the remedy that is available to the party was to question the said order. They kept quiet without questioning the said order. Now, this court do not find any change circumstances from this order, and all these aspects were rightly dealt with by the family court in the earlier order. The family court was right in holding that already when there is an order is passed, and this application cannot be considered, and this cannot be termed as a change circumstances. And the court has taken note of the capability of the parties to earn than whether she is earning on the day or not. In the considered opinion of the court, the order of the family court do not seek any interference, and accordingly that petition is dismissed.
My lords.
And
One-
all this IA for dispensation is allowed. Yes, next.
My lords, only one fact, my lords. Permission. My lords, she lost job then and now also she has lost. She had made her efforts and could not get the job, my lords. That's what is stated.
It is she couldn't get the job. That is a change circumstance. Yes.
Please.
Come for B group, my lords. It is already heard, notice has been already issued. Let it come for B group, my lords.
This is matter and B group.
Interim order, maybe.
Interim order order granted is extended. No representation for the respondent. This is matter after 2 weeks. Yes.
Lord, I appear for the petitioner, my lord. Wife is before this court, my lord. Interim maintenance application was partly allowed. 20,000 has been fixed for
You're
the
seeking
wife.
enhancement.
Enhancement, my lord.
What is?
Grateful.
Is 20? Give that. Give the report. the MCs of the year 2015, when this writ petition has come up before this court on the last occasion, write the date, wherein they sought a direction for the early disposal of criminal miscellaneous number 446/2015, pending on the file of the civil judge and JMSC at Sira. This court has called for a report from the concern, as this court was surprised to see that a criminal miscellaneous of 2015 is not even disposed till now. Neither the criminal miscellaneous is disposed, nor the interim maintenance is granted by the court. Now a report is placed by the court stating that the respondent has denied the relationship between the parties. The said report placed before this court is not convincing. If the respondent is, if the husband has denied the relationship, it would not take 10 years to decide that. It is very unfortunate that a petition of 2015 is pending till 2025 and without there being any order from the court. The court shall decide these applications in a time-bound manner. At least the interim application has to be considered within a time-bound manner, and even for final disposal of the criminal miscellaneous also, whatever are the reasons, it cannot take 10 years. It is, as per the report, it is not forthcoming that any stay is granted, in any of the petitions, stay is granted by this court. In those circumstances, this court is of the view that this application has to be, this writ petition has to be allowed, and there shall be a direction to the court to dispose of the matter within 2 months from the date of the receipt of the order, and it is made very clear that no further time will be granted, and the court shall not grant unnecessary adjournments, and even if there is any objection from the other side, within a time-bound manner, if the issue shall be decided. Accordingly, this court is passing the following order. So and so is allowed, and the parties are directed, and the trial court is directed to dispose of the matter within 1 month from the date of receipt of the copy of the order, and no further time will be granted to. And then both the parties shall not seek any unnecessary adjournments, and court shall not entertain the in the interest of both the parties. Yes, next.
The husband before this court, Your Honor. The
Yes.
husband is challenging the interim order passed by the trial court.
What is the order?
Order is 25,000 per month. My earning capacity is 15,000. I am the qualified as a PUC.
Let's see what is the observation of the court with regard to your income.
The court has considered that
Come to paragraph 14.
so considered by the present status of the case, I am opinion that the present case is filed by the petitioner wife seeking a maintenance herself and with daughter. The ground of negligence act of the respondent are relationship undisputed fact in the case, and therefore the circumstances in the instant case, the case stage is case for claim of application of the considering based on the prima facie material available on the record, but it can adjudicate in detail by conducting a separate mini trial. Hence, the considering the status of the parties is goes to establish that undisputedly the petitioner's
Wife and child, or only wife?
wife and child.
And where did you say that your income is 15,000? Show that.
I have produced the salary certificate issued by my annexure K, page number 72. Issued by the coffee estate owner, saying that he is working working in his farm and earning as 15,000 per month. As a working as a writer, nothing but a supervisor in the estate.
The respondent acknowledges having received a share of 3 acres in survey number through family partition, which he sold on 23/4/2024 to meet his legal necessities.
Yes.
3 acres, so how much, what is the amount you got?
But presently I have
No,
no,
no, it is sold on 23/4/2024, not even a year. What is the amount you have received?
but I have no instructions regarding that.
That is relevant. That is relevant. You will not get, from selling a coffee estate of 3 acres, you will spend it only for legal necessities. Get instructions. This is matter tomorrow.
I have ready to deposit a certain amount.
Now you say 15,000, can the court grant 15,000 as maintenance? No, then it has to be half of it. You get instructions with regard to that. It is submitted that, in the order, it is observed that 3 acres, 3 acres of the coffee estate fell to his share in the family partition and he sold it in the year 2024. What is the amount he has received from such transaction is not forthcoming. The petitioner shall place, the counsel of the petitioner shall get specific instructions. This is matter tomorrow. Tomorrow or day after?
It may be on 18th. 18th.
Yes, next.
In respect of case number 2, I am for the petitioner.
Any interim order in your favor?
In respect of payment, every month I am paying the amount.
As per the order passed.
Yes, there is no due. Recently,
No
they have filed one.
representation for the council in RPFC number 109 of 2022.
No, madam. RPFC 182/119.
No, 109, there is no representation, I'm saying.
Yes.
Counsel for the petition in RPFC number 182 of 2019 is present before the court and he submits that as per the interim order passed by this court is complying with the directions. This is matter after 4 weeks. There's a stay in this? No representation for the petitioner. Is this matter for dismissal day after tomorrow? Yes, 24 counsel for the respondent is present.
Hearing for petitioner, my lordship. This RPF is filed for the enhancement of the maintenance, my lordship, which is at page number 10, my lordship.
When did you file? Today you filed. This is matter on next Monday at the request of learned counsel for the respondent that he has filed wakalat today. Huh? Both will come. Both you will hear it on that day.
For the petitioners, my lord. This RPSV is filed for challenging the trial court order ordering the petitioner to pay 10,000 per month in a maintenance, my lord. The allegation is the respondent wife alleges that the dowry has been asked by the petitioner's parents, and also she alleges that there was a harassment by the petitioner's family members. But she has not made any legal, she has not sought for any legal remedy, she has not sought for divorce, she has not sought for any domestic violence. She directly files for a criminal miscellaneous for asking for the seeking for the maintenance. Moreover, the petitioner is a cancer patient. He is suffering from a stage 4 cancer. He was not able to attend the trial court this thing in Chikmagalur.
What is the observation of the court while granting maintenance?
The court has observed that the petitioner is well capable of maintaining the.
This aspect that he is suffering with cancer was not brought to the notice of the court.
No, my lords,
Why?
because he is residing in Bangalore. The same he has sought for a transfer of maintenance to Bangalore, my lords. The same is pending before this honorable.
What is the material before this court to show that he is?
Document number 5 have produced all the medical reports and the bills. Page number 61, my lords, from 61. All the chemo drug he is taking, all the expenses he has made towards the.
What is his
cancer.
income otherwise?
He was in a job. He left
Fine,
it,
how much salary?
he was drawing around 30 to 35,000 salary, my lords. Now he has left the job because he is suffering from a cancer.
Why were these things not brought to the notice of the court?
Because he was unable to attend before the.
It's an ex parte order.
It's not ex parte order. There was a wakalat filed about this thing, but due to his continuous.
No,
this
please
thing.
understand, as on the day, all this situation was prevailing.
True, my lords.
Then when you have not brought to the notice of the court, and how do you expect this court to look into all that?
That is why, my lords, he has sought for a transfer petition. Meanwhile, he couldn't attend for a maintenance, this thing in the trial court. The same for the transfer, it was pending before the Honorable High Court. It's still pending before the Honorable High Court. He
Submitted
couldn't,
that
he
the
could not lead his
petition is
evidence.
suffering with stage 4 cancer, and is spending huge amounts towards his treatment. All these things were not brought to the notice of the court. Yes, he has already sought for the transfer of the petition. Considering the submission, there shall be stay of all further proceedings for a period of 4 weeks. In the meantime, the notice to respondents. This is matter after service of notice.
My lord, this writ petition is filed. Petitioner has sought for the writ of certiorari to quash the order dated 17/9/2022 on IA number 6 and IA number 7.
How much is the amount granted?
My lord, it is for recall and this application.
Recall. Hereby dismissed. Please come to the order.
My lord, page number 12, Annexure A, my lord.
This is an MC of 2021.
Yes, my lord. My lord, the advocate representing respondent, he was held up in another city court.
Read from paragraph number 8. Paragraph number 8.
My lord, in annexure.
Impugned order. Paragraph number 8 of the impugned order.
My lord, on 18/4/2022, the respondent wife filed IA number 4 under order 33. Sorry, my lord.
Have that with you.
18 rule 17 and IA number 5 under section 151 of CPC for recall of PW1 for the purpose of cross-examination. After hearing both sides, the said 2 applications were allowed by order dated 24/6/2022, and accordingly PW1 was recalled for cross-examination subject to payment of cost of rupees 500. After recall of PW1 for cross-examination on 2/8/2022, PW1 was present for cross-examination, but the counsel for the respondent sought for adjournment, and accordingly the matter was adjourned for the cross-examination of PW1 on 10/8/2022. Again, when PW1 was present, the counsel for respondent sought for time to cross-examination. But as there was no ground for deferring cross-examination for consecutive 2 dates of hearing, therefore, by order dated 10/8/2022, the prayer of the counsel for the respondent was rejected, and once again the cross-examination of PW1 was taken as nil and posted the matter for evidence of respondent. My lord, because
let me complete this order.
On 25/8/2022,
Yes.
It's only
What
one
is-
opportunity to cross-examine my lords PW 1 and 2.
No, this is a repetition of 2022.
Yes,
Stays there.
yes.
Whose MC is this?
This MC is filed by my lords
So
respondent.
conveniently from 2022 till now, the matter is stalled.
So heard, not represented.
But still it can be heard. How many times it has come up before?
No,
the
it is
court?
only my lords
This
thereafter.
is like somewhat very sorry state of affairs as far as this family matters are concerned. For this simple reason, from 2022 to 2025, the matter is pending before the court.
I represent the wife, my lords, but husband remained absent. Husband's petition, my lords.
Yes, husband's MC.
Husband's.
But you filed the application
I
for
filed the application.
cross-examination of PW1. One memo I can see in the year 2023.
So by then, my lords, may submit this, my lords. By then, GM and GMFC both were taken up together. My lords, for obvious
Which
reasons.
court is this?
Family court, Mangalore, my lords.
Mangalore.
Yes, my lords.
I think the Mangalore has already, they have, no, this is 2021. They have already completed all the matters for 2021 long back.
This is because of my lords
Granted
stay
by this
granted pending.
So what is that the wife is gaining by this stay?
It's of course, it's
And will direct the court to dispose of the matter within 3 months.
please.
The agreed with the order dated 17 September 2022. Passed in I number
6 and 7.
6 and 7.
Yes.
6 and 7. Dated 17
17.
September 2022. The wife is before this court. Husband has filed the MC 236 of 2021 seeking divorce on the ground of cruelty.
Yes, 13(1)(a).
Seeking divorce on the ground of cruelty. In that, the present IAs were filed to recall PW1 for the further cross-examination. That came to be dismissed by the court, observing that earlier also he has sought for such an application and the same was allowed on 24/6/2022 by imposing costs. And it was a duty of the counsel for the respondent not only to pay the cost imposed, but also proceed with the cross-examination of PW1 on the next date of hearing. But in this case, after recall of PW1, by order dated 24/6/2022, the counsel for the respondent failed to cross-examine. Even after granting 2 adjournments. Under those circumstances, the court was of the view that such an application cannot be considered. Then counsel appearing for the petitioner wife submits that the court ought to have considered the fact that as on the day he was before the other court, as such he could not cross-examine PW1 and sought for time. And if the PW1 is not cross-examined, recalled and further cross-examined, it would cause a lot of prejudice to the wife, and these aspects were not considered by the court. Next para, though notice is served on the respondent, there is no representation on behalf of the respondent. This court has perused the order. On the face of it, it appears that there is no irregularity or illegality with the order passed by the court. This matter is pending before the court from the year 2022, and this court had granted stay of all further proceedings. And from 2022, the entire MC proceedings are stayed. The state for not granting an opportunity to recall in the year 2021, a matter is 22, a matter is pending before the court till 2025, and stay of the court proceedings were granted. It is very unfortunate that the matrimonial proceedings are going on in this manner. In the interest of both the parties, this court deems it appropriate to set aside the order impugned and allow the petitioner to cross-examine PW1, and the parties shall appear before the court by 25th of June.
Next date is scheduled on 16th July.
No, we'll say we'll for by 25th of June, the parties shall appear before the court by 25th of June without further notice. And the court shall dispose of the matter within 3 months from 25th of June. And no request for unnecessary adjournments shall be considered by the court. This MC being 2021, as already the other matters are disposed of by the court, this shall also be disposed of expeditiously and no further time will be granted.
Order will have to be quashed. Impugned order will have to be quashed. And
Accordingly, this court is passing the following order. Order dated so and so is set aside. And the IA number so and so is allowed. Same, all that incorporate in the operative portion.
great.
Yes.
Appeal for petitioner, my lord. The application filed by the father seeking custody of the minor child for a period of 7 days, as he was planning to come from Dubai to India, my lord, is dismissed, my lord. My lord, but kindly see the conduct of the respondent, my lord, as Annexure B, my
First of all,
lord.
let us see the impugned order. Where is the impugned order?
My lord, by referring the order passed in the.
Let me understand first. Please come to the impugned order. Then you can make your submissions.
My lord, but kindly see Annexure, my lord. Annexure J, 52, my lord.
Who has
54.
filed the GNWC?
JWC filed by the grandparents as well as father, my lord, wherein order has been
You
granted.
are appearing for?
Appearing for the husband and grandparents, my lord.
Yes.
Yes.
The application filed under so and so is hereby allowed.
Well, kindly see the conduct of the respondent, my lord.
Let me read the order first. Now, what is wrong with this order?
My lord, kindly see the conduct, my lord. Here, my lord, kindly see Annexure B.
We will not see the conduct. We will see the impugned order.
Impugned
What
order,
is
my lord.
wrong with the impugned order?
Wrong, my lord. The findings referred in the content petition, based on the findings referred in the content petition, my application is dismissed, my lord. And also, the finding is given in the content petition only with respect to grandparents, my lord. Kindly see, my lord. At page
No.
para number 6 of 58, my lord.
Is this the impugned order or not?
Is the impugned order, my lord?
Correct.
Yes.
So let's not go to that now. This impugned order is questioned by you.
Yes, my lord.
On
That,
what
my lord.
ground?
My lord, since more than 4 years, my lord, even for a single time, the order of this court not been complied,
If
my
it
lord.
is not complied with, you will file another writ petition. If an order passed by the court is not complied with, can you file another writ petition?
No, my lord, kindly see, this is second round of litigation, my lord. My lord, this is second round of litigation. Earlier also there was writ petition
But I
filed by
understand, Mr.
respondent, my
Counsel.
lord.
You are questioning an order.
Yes, my
First
lord.
of all, you should say how you are aggrieved by this order.
Kindly see the.
You are not aggrieved by this order. You are aggrieved by the conduct of the wife in
No,
not
I agree
implementing
with the
it.
order, my lord, because my application filed is dismissed.
Where is that?
Kindly see, my lord, annexure.
No, in the
Annexure came, my
impugned
lord, page
order,
number
in the
54.
impugned order, you show where is the order, where is your application dismissed?
Kindly see page number 54, my lord.
32 is the order, 34 it ends.
No, my lord, 54, my lord.
Which is the impugned order?
Order dated 6 December 2023. At annexure came, my lord.
This is the impugned order.
Yes. Kindly see, my lord, reasons, my lord. Can I be page number 58, my lord, para number 6. In the present case, the petition number 1 and the respondent are the husband and wife, and their ward is aged about 7 years. The petition is filed on 22/1/2021, and this court, with order dated 25/8/2022.
Where is the order in the contempt petition 13/9/2023, page number?
Contempt petition, my lord. At annexure G, my lord, page number 45.
45.
Here also para number 6, be kindly see, my lord. In contempt petition, my lord, the respondent undertook saying that she will going to abide by the orders. Para number 6 relevant, my lord. In view of the above statement by the respondent that she has no hesitation to abide by the orders, and also in order to give quietus to issue, which otherwise can become a repeated cause of action, we deem it appropriate to direct the CPI NR Mohalla Police Station to depute one WPC who shall accompany in the petition number 2 and 3 and in mufti to the residence of the respondent and shall remain with the petition number 2 and 3 till the child is handed over to their custody by the respondent. And the petition number 2 and 3 are permitted to spend 2 hours with the child. The respondent is also at liberty to accompany the child and remain with the petitioner number 2 and 3 if she desires. The arrangement is permitted only on the any 2 Sundays in a month and shall be continued for 4 visits. The present piece is so and so, my lord. This is with respect to petition number 2 and 3 over the grandparents, my lord. My lord, may kindly see Annexure B, my lord, where there is a order permitting the petitioner, petition number 1, who is the father, my lord, as and when he comes from Dubai, my lord, he can visit the take custody of child for 2 days, my lord. Till today, my lord, even if for single time it has not been complied. He is planning to come to India to see her child, but the respondent is not complying the order.
So what is to be done? What is to be done? If he is not complying, if the mother is not complying, what is to be done? That I understood from the beginning. What is your submission?
With the help of police also, my lord, we tried a lot, my lord.
So now what the court will do? Court will go?
No, not like that, my lord. There should be a specific direction, my lord.
There is a specific direction already. Higher court, whether it is a family court or high court, doesn't matter. It has to be implemented.
Not with respect to petitioner father, my lord. Let there be a direction to accompany, to execute the order with the help of local police, my lord. Because he planning to come to Dubai to see.
If you are seeking execution of an order passed by the court, go before the very same court. Go to the executing court seeking that order. Why should the high court interfere in these kind of things?
My lord, the thing is, my lord, we made a similar application, this impugned application, my lord, where I sought custody of only 7 days, my lord, which is dismissed. My lord, kindly see the reasons.
All these are not going together, or your submissions.
My lord, kindly see the reasons assigned by the family court, my lord. By referring the findings in the contempt petition, that with respect to petition number 2 and 3, my application filed by the father is dismissed. That order is not related to the grand petitioner itself, my lord. Father. Madam, kindly see the impugned para number 6 of the impugned order, my lord.
It is very confusing, Mr. Counsel, the facts. At one stage, you will be saying there is an order that is not complied with.
Yes.
Number 2, you will say that court had dismissed my application. Which things the court has to consider? Court has to consider the non-compliance or dismissing your application. Either you have to be on one stand. What you want the court to do?
Now the situation is, my lord, I am working in Dubai, my lord. I want to see my daughter.
You want to see your daughter, there is an order, the wife is not complying with that, I will not go into that aspect.
Yes.
That you forget. Then come to the next stand.
But for non-compliance, my lord, due to non-compliance, my lord, I made one more application before the family court seeking 7 days custody.
The court was right. How can you make that application? Now, if there is non-compliance, you will come up with another application. Or you seek implementation of that order. Will not waste much time on this.
No, my lord.
Please come. I number agreed with orders passed in GNWC in IN number 14 in GNWC number 4 of 2021 dated 6th December 2023. The father is before this court. The father along with the grandparents has filed an application, has filed a GNWC 4 of 2021. In that, an application was filed by the father and the grandparents. That's IN number 3. And that came to be allowed by order dated 25th August 2022, whereby the court had in that order, the court, apart from mentioning about how the visitation has to go with the grandparents, had also mentioned when the father returns to India and he wishes to have the custody of the child, he can have the custody of the child for 2 days with prior information, and the wife shall cooperate in that regard. Thereafter, a contempt is also filed. That is, where is the contempt petition?
Annexure G, page number 45.
A contempt is filed, and an order was passed whereby the parties were given. The court had directed the police for the protection, for the implementation of the order.
Only with respect
in the contempt case. Then, in respect of Again, the father has come up with IA number 14 saying that to hand over the custody of the ward for 7 days to the father. It is the case of the father that the wife is not complying with the orders passed by the court and is not able to exercise the visitation. And the court can now not, without considering all these aspects, has dismissed the petition, saying that the parties have to comply with the order of the court in civil contempt petition number 1158 of 2022, dated 13/9/2023. As such, the same needs to be set aside, and there should be a direction to the police to comply with the order. Already, the court has passed an order.
With respect to petition of two grandparents, my lord, it is not with respect to father.
Then you file a contempt for yourself also, but not, we can't execute the order in a writ petition, in a separate writ petition. The father, the counsel for the appearing for the father submits that the contempt orders are in respect of the grandfather, but not the father. Next part. This court, the notice is served to the respondent mother, but there is no representation. Having heard the counsel for the petitioner, peruse the material on record. This court has held the notice to so and so. Look at it, sufficient on so and so. This court has perused the order. There is already an order by the court granting visitation to grandparents and the parent. When there was non-compliance, the grandparents have approached the court, and this court has granted protection. Thereafter, the petitioner has come before the went before the court and sought for 7 days custody. Court had directed the petitioner to act as per the order passed in the contempt. It is a contention that said contempt is in respect of the grandparents, but not the father. In this case, admittedly, in the GNWC, an earlier order is still subsisting, wherein the father was granted visitation for 2 days, and if the same is not complied with, the father has a means to execute the order by filing a contempt or whatever is the remedy available to him. And for that, another application before the court is not warranted. Hence, it is left open to the petitioner father to execute the order of the family court dated
April 8, 2022,
5th August 2022. Accordingly, that petition is disposed of.
The observation may be made. The observation may be made to file necessary application before the family court, my lord.
For what?
For executing the order, my lord.
Okay, then I said it is left to you. You are at liberty to do it. Yes.
This main matter is already disposed of, my lord, on 31/20/25, my lord. Already paid the arrears and alimony is also paid, my lord. This petition is not survived for consideration.
It is submitted that the main petition itself is disposed of. The main MC itself is disposed of, and nothing survives for consideration in this case. And the memo is filed in that regard. Memo is taken on record, dismissed as infructuous. Yes, 28. 29.
Let's.
Yes.
Two petitions are there arising from the petition. As one is the maintenance order and the other they are seeking.
Which is the maintenance order?
Well, first one is the maintenance petition that the wife has filed.
You appear for the wife?
Well, I am for the wife.
You appear for the wife and you're seeking enhancement.
Enhancement. 20,000.
And yours is? What was granted? Let's see. Let's look at the visitation first. Let's see that order impugned. It is there in the first petition also. Give the second. Give the second. Yes, page number.
23. Reasons are 39, page 39.
I think something wrong with the pagination. 4376 I'm looking at.
Plus 4376 is for the
14708. She has given first that. It is here. Page number?
page number 39 is already number 23.
Filed with or hereby partly allowed. The respondent is permitted to participate in school meetings, nuisance and affecting the future of the child. The respondent is permitted to make audio so and so. Is permitted to take interim custody of the child from 9 a.m. to 6 p.m. on every Sunday, 50 during summer vacations, Dasra vacation. And what did you sort?
I have sought for Friday night till Sunday night, not every weekend.
Then when will the mother spend the time? That's a holiday, and he has to do. What is the age of the child?
Is now going to be 11 in next 3 months, September. 10.9. That's his age.
What do you say about this, about the interim custody?
Because when both the petitions came up for hearing, in fact, I did suggest on the instigation of the court whether this could be settled and what. Now, Millards, the only thing that I asked is 20,000 was what was awarded by the court to the child. And regards the educational expenses, both the parties were to bear 50-50%. Now, as per the affidavit of assets and liabilities that I have produced before, the husband was employed in Brillios Technology, earning about 3,35,000.
What about your income?
Millards?
Your income?
That is 1,16,000, which they also have admitted. So I just said, proportionate to the income of the parties, let him bear either the entire educational expenses or whatever the proportion the court decides I'm okay. Then I will sit and convince my party every weekend from Saturday, instead of, I think it is granted from morning to evening, Millards, every Sunday, 9 a.m. to 6 p.m. Instead, I could say, I could sit and talk to
Saturday
to Sunday.
Saturday morning to Sunday morning.
Sunday morning, whatever, Millards. I did say that, but however, they were not for it. And they did produce later on.
What is your client's, what are your instructions with regard to maintenance?
Regards to amicable resolution, we had proposed shared responsibilities. Both of us are in mind. The child was with me until she accepted the child overnight without.
Male or a female?
Son. So now the child is with me all along, and suddenly she removes the child from 37 police complaint against the child. I had to quit my job to take care of the child. She wanted to go for a job. I had a regular job in Infosys. I have quit that job. 3 years I stayed back. Then I took that, I getting back into a formal environment becomes difficult once I put a regular job. Number 2, I took her to consultant because I wanted to be a part of the child's, be with the child. For the formative years, the child will be with us. After he goes away, he becomes a part of the, he moves away from the parents.
So you had your 50% of vacation in summer. So that went on well.
Yes. She sent. That is why all that I proposed.
Then what is the difficulty for a co-parenting?
That's exactly what, the council is submitting the settlement of the entire this thing. There are 2 MC proceedings and there are 2 custody petitions. One filed by the husband, one filed by the wife.
MC filed by whom?
Plus?
MC filed by whom?
One is filed by the wife for divorce.
On the ground?
Cruelty.
Husband restitution.
So
now both of you do not want to join the husband.
Definitely we got to know that I don't think there is going to be any kind of.
So there is no the MC anyhow, like when both of you are not interested, then there
should not be an issue.
Yes.
That's one thing.
Then
Yes.
that is one.
Yes.
Then coming to the co-parenting. The shared parenting plan. Yes, it is. You can as well go with that.
I think the parties have to sit across the table and regards the co-parenting, that is what needs to be discussed. As of now, Millards, the terms exchanged are only between the council.
Where do they stay? They stay at a distance.
Both are staying in Bangalore.
Then why can't you explore the possibilities of a co-parenting and a joint memo in that regard? You know, when the boy is staying for 50% of the vacation is given to the father
Yes.
and he's comfortable, things are going well, what's the difficulty of the mother?
It is not as if, like how it is put. Even regards the co-parenting, what is the father ready to do for the child? Or for that matter, what is he expecting is still today not known.
Then you do one thing. What is that you are expecting in a co-parenting? Give your proposal to her.
All right.
And let her put it to her client and come back.
Parenting, yes. My lords, as regards divorce, my lords, I also exchanged this.
What we are saying, co-parenting, term, one term will be, one term will be. We have 3 terms. So by rotation, we take each term. So the child will be, I will not meet the child, will not meet. Instead of splitting the child every 2 days, 3 days, let the child be with her for 1 term. We have 3 terms in the school. Next term with me. Next term with her. So in the year, I will get only 1 term. Next year, it will be going on rotating. So we have every 3 months, the child will be.
And about you spoke how the visitation has to happen also is there. That is one aspect. Then about the contribution.
When the child is with me, I will be free. When the child completely I will take care. 3 months the child is with me. School, every other expenses I will take care. When the child is with me, she takes care. So there is if they do not want 1 term, we are even ready to go 50-50 completely without 6 months yes, 6 months with me. We are ready to work out in any manner. What was told when it comes to me was that she is not interested in co-parenting.
Plus, as regards shifting 1 term here, 1 term there of a 6 months, that would disturb the child is what I had told. Definitely, there is no this thing. But as regards contribution from the father,
going to the school and his academic activities,
because the child
it can't
is
be
doing
every 2
extremely
days.
well.
No. It can't be on every weekly basis or generally in this
I would
joint. You have a guidelines for that joint parenting and all.
Correct.
Which is approved by some of the high courts. Just look at it
Plus, I
and
think
explore
it
it.
is-
Why the
Yes. But that was quite some time back. That was I
so
think,
recently Delhi High Court or the Bombay High Court they have oh, is it so?
To be honest, from past 5 years, there has been nothing other than the Justice Krishna Kumar's judgment, which says about custody, shared parenting, all of that. While the petition is pending, that is what it says. However,
What happens is, even for the boy also, it will be comfortable if there's 6 months period. And in that period, how the mother is going to have the, visitation or the father, vice versa. It can be decided.
I also felt that if at all the father is ready, whatever
So what will happen is 1, 2, 3 terms, and as her proposal that whenever the child is with one of the parent that they will be spending, then this 3 will become a confusion. 1 year, one will be burden. If it is half, it will be like it's a fair proposal.
The child is doing extremely well as compared to earlier with the mother. She is taking care.
He'll do good. He'll do well with the father also once he starts deciding.
Why not from weekend? That also could be explored.
That won't happen. That where will the other person will have the satisfaction of having the custody of the boy?
Also, there is no clarity on what are the expenses that the father is ready to do for the child, or for that matter, for the divorce for the mother.
For example, the fees of the boy, 6 months. 6 months, the entire fees will be paid by the father. 6 months will be by the mother. And as long as the boy is with the father, he will completely take the responsibility, whatever of the expenses. Remaining 6 months, that would be with the mother.
Look, that I think is not a very good proposal. 6 months, as it is, the mother is taking care. 21, the father left the job. 3 years, he never
3 years never contributed anything.
Still 21 years. Still 21, as per their own statement, only till 21.
He had his savings and he was contributing to the home. The house is no more rent. Running expenses, what they were doing, and the application for maintenance is the house.
I think both of you sit and discuss, and it is when the boy has no issues and he is comfortable with the other parent.
We have tried this, because your lordship, if it is possible, we have tried, and this is past 6 months we have lost out, and I'm not having the access to child details. I have to wait for
Ask the parties to
We
come,
have to, Milord,
ask the
what we-
parties to come tomorrow. They're there now.
No, she is not there.
Where is she?
She's gone for work.
No, like she's in
Bangalore.
Bangalore.
She's in Bangalore.
She can come tomorrow?
Tomorrow, yes.
Yes, tomorrow
I
we'll
think
take
that
up
would be an issue.
at around one, or I mean, there's already one more matter tomorrow at 2:30. We'll have it around 3 o'clock. 3
3 o'clock, yes. Very well.
This is matter tomorrow. Tell the parties and, let them think in those terms, how the court is proposing
Definitely.
in chambers tomorrow. Yes, next.
I pay for the petitioner in this matter. But the writ petition, my lord,
Suppose
against
this matter by the time the amounts are not paid, the stay granted which court will stand
it
vacated.
has been paid.
It's paid?
Please.
Then we'll hear it later if the amounts are paid. Let's this matter after 10 days. Yes.
Petitioner by me, please, your lordship.
Yes. Yes. Please come to the order.
May I please, your lordship?
Yes. So now the custody is shifted to the mother.
Yes, please, your
The
lordship.
boy is with the mother now.
Presently, yes, please, your lordship. In fact, please, your lordship, the child was in fact with the parents till 17/4/2025.
I remember all the facts. I remember all the facts. Now the issue is like this. Now, according to you, you're raising certain allegations against the wife, saying
Yes,
that
please,
she's
Your
not, she's having some illicit relationship with somebody. And in that regard, you want to place before this court the photographs or the WhatsApp conversation and other things,
Certainly.
which is definitely he's a boy aged 3 years.
Certainly, please, your lordship.
So you've already filed the GNWC. She has already filed the GNWC.
Yes.
Now, at this point of time, shifting the custody to the father, without adjudicating all these issues, when both of them were together till 17/4/2025, how it is, and what is now this court will only be exercising the parent patriae jurisdiction, how it is going to affect the welfare of the minor. According to you, how it is going to affect the
please, Your
welfare of the
lordships.
minor?
Now, please, your lordship, the application which is now before this lordship is that filed application under section 25, please, your lordships, which speaks about handing over the child to one of the guardian. So now, please, your lordship, the child, as on the date of filing the petition, was with the father, who is also one of the natural guardian, as that of the mother, please, your lordships. Now, please, your lordship, the application filed, if your lordship looks into the IA, please, your lordships, which will be, your lordship will find it at ink page number
Yes.
48. So the relief sought by them is to return the child. So by their own wordings, they would establish that the child is with the father as on the date of filing the petition. So now till 17/4, when the child was in the custody of both the parents, so the mother cannot take the advantage of claiming that the child was with the mother. So there was no separation between the husband and wife till 17/4, please, your lordship.
At the tender age of the child, court always takes it that he should be with the mother.
Certainly, I will try to demonstrate before the court how the welfare is better with me than that of the mother, please, your lordship. Now, please, your lordship, this
Mr.
would be
Counsel,
relevant.
no, before going into all that, 1 minute, before going into all that, what this court is thinking is, what is going on in the mind of the court is, now we will say every weekend, like on Friday to Sunday, Friday night to Sunday morning, Sunday evening or Sunday morning, let the father have the custody of the child, and let the remaining days let him be with the mother, and let the court decide this application. That would be an appropriate order in the facts. Every Friday evening, let him take the child, give him back on Sunday evening.
Your lordship, pass over the matter till 2:30. In the meanwhile, I'll.
He's there, ask him to come. Ask him. Now, all the citations are not required for the reason, father also, father, you can file. Father also has a right to, because he was staying and the court also have seen that the boy is attached to the father and father has every right to see the child. So, no, he's not going to school. What does it mean? Okay. No, we'll also make sure that both of you, either of them should not ill advise the child.
All misleading, please, your lordship.
No, no, it's
They're
okay.
just
What
trying to
happens
infringe
is,
upon the court
what
and all these
happens,
things.
both of you wait for a minute. What happens is, that way will ensure, yes, what he says.
Yes, please, your lordship, we'll go by the suggestion of this court.
And let the court dispose, hear the matter in accordance with law.
But on merits, let that be kept open, please, your lordship.
Yes, no. How, where both of them are staying? Is it near to the other's house? Huh? Huh. Where is the school? Hmm. No, for a boy of.
They are again trying to mislead the fact.
If both of you want to talk, court can't help you. Please wait.
Because if the statement is right, then I would not interfere. Now,
Because court is not considering any of the statements. Please listen what the
Certainly.
court is proposing. Now, a boy of 3 years, now he is going to school. His school, he must be going to school on Friday. No school for Saturday. No school, there won't be any school. So on Friday, the father will pick up the child from the school, and will drop him back on Sunday evening. That's how the arrangement should go on till until the consideration of this application. And if any of the important days on birthdays or any other things he wants the custody, he is at liberty to move an application before the court whenever it is required, or in the summer vacation or whatever it is, it's open for him, and let the court decide the matter.
let the lordship consider to divide the vacations, summer vacation, Dasara vacation, so that both the parents can have the custody, so that again, this.
No.
This is again, we are trying to
What
negotiate.
happens is, why you want that litigation again? No, but when, for example, the vacation would be for Dasara and for the winter vacation and the summer vacation. So on all these days, the first part would be with the father, the second part would be with the mother, 50% of the vacation. That would solve the issue without unnecessary, again fighting for it and aggravating the situation. The agreed with order passed in. That I believe. Either of the parties, neither you nor him. The agreed with orders passed in IA filed under 25(1) and 2 of the Guardians and Wards Act, dated 10th June 2025. Both the father is before this court. The mother has filed JNWC 42 of 2025 seeking custody of the child. It is her case that till 17/4/2025, both the parties are residing together, and on 17/4/2025, without the notice of the mother, the father had taken the child, which made her to come up before the court, filing the JNWC petition. And the court had passed the order impugned, directing the father to return the custody of the 3-year-old minor to the mother. Land counsel appearing for the father submits that he has made certain allegations against the wife with regard to the conduct and how she is living a adulterous life. And he also placed before the court some of the photographs and the WhatsApp conversation. Land counsel appearing for, and it is submitted that it is not in the welfare of the child to stay along with the mother. Land counsel appearing for the mother submits that now, unless and until an application, the same is produced before the court, but through an application under section 65B of the Information Technology Act, the same cannot be considered by the court and it is part of the trial. At this stage, it cannot be, there cannot be any observation on that. Further, how the welfare of the child is affected is also one of the issue that has to be dealt with by the court. When the matter came up before the court on 13/6/2025, this court had interacted with the parties and the court had passed an order that first the child has to be handed over to the mother as per the order of the family court, and the mother shall not precipitate the execution proceedings, and then this court will hear the matter on the merits of on the merits. Today, this court has heard both the counsels. As rightly pointed out by the land counsel appearing for the mother with regard to the adulterous life and other allegations that are made by the father against the mother cannot be decided by the court at this stage. And admittedly, both the parties are staying together till 17/4/2025. Considering the age of the boy, the custody that is granted by the court to the mother, this court do not find any reasons to interfere. When this court had interacted with the parents and also seen the boy is as well, along with the mother, he is also attached to the father. The father needs to also requires the boy also requires the company of the father. Though no application is before this court with regard to visitation and all, this court exercising the parent patriarch jurisdiction in the interest of both the parties considers it appropriate to pass the following order. Number one, on every Friday, the father shall pick up the child from the school and again shall return the child to the mother on Sunday evening by 5 o'clock. That father will do.
3 years more, still the child is not admitted.
And in case if any of the
father is equally educated or more qualified than the mother.
Why father is not capable of teaching him?
He is a double graduate. It is he who has always been.
And during the stay with him, the father has to take care of the requirements of the child with regard to any exams or any academic activities. Next, number two, when the child is with the father, it shall be ensured that not with the father, both the parents shall ensure that they do not speak ill of the other parent, and if that kind of any of the conduct from both the parties will be considered very seriously, and seriously, and court will pass, the family court shall pass appropriate orders when any of that nature is brought to the notice of the court. Next, on the child's birthday and any important festival in the family or in the religion, on that day both the parents shall have 50% of the first half shall be with the mother and the second half shall be with the father, and by end of the day the boy shall be sent back to the mother. Anyhow, whatever it is, whatever she has, she wants first half or second half. Huh? That's what I said. Even before also I said so. During the summer vacation, the 50% of the vacation, the first 50% of the vacation shall be with the father, and the 50% of the second part of the vacation shall be with the mother. Number three, the same thing applies to Dasra and winter vacation. Winter vacation. Next one, if any of the aspects that are not dealt with, and any indulgence is required with regard to the visitation, the parties are at liberty to make an application for further arrangement without altering the existing arrangement. Accordingly, the writ petition is disposed of, and the family court and the court shall consider the same in accordance with law.
Because immediately after vacation, they manage to pick the child. And it may start from after 2 days of life.
This
So
is-
that you can ready the child and.
Father can also ready the child. ಇದೆಲ್ಲ ಅದ್ ಬಂದ್ಬಿಟ್ಟು only trying to pour.
No, the second day of from the second day of the vacation, that 50% shall be counted, and the custody shall be given. Yes. Huh?
Because I am being directed to pick the child from the school, so there is no question of fighting.
Yes. It is the council appearing for
Copy is not
the,
furnished.
has filed her objections and the same on taken on record and give it. Yes, next. Yes.
As I'm appearing for the petitioner,
What is the specially
the
mentioned?
objections raised have been complied with, my lords. Convenience, kindly have it to the next week, my lords, for hearing. In the meanwhile, I shall file my objections to their IA, my lords.
Why is this specially? I told that not to list this criminal and miscellaneous. Why they listed it again? Tell them not to. Yes, list this matter after 2 weeks.
Please, my lords.
Are you complying with the interim order?
All have been done, my lords.
Yes, is it so?
I shall file my objections to their IA, my lords.
That's what I'm saying. Is he complying with the interim order?
There's no conditions on the interim order, my lords.
It's a blanket order.
My lords? No,
No
it's not.
condition.
It's not part heard, my lords. There is a stay on the final on the CMS proceedings, and there's no conditions imposed.
conditions.
No conditions. Please, my lords. I shall.
Yes. Pose this matter after 2 weeks.
Much.
They'll indicate the date. Signature.
Court officer? Hello? Court officer? ಸೇಲ್ ಲೀಡ್ ಕಾಪಿ ಇಲ್ವಾ? ಅವ್ರಿಗೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು ಸೇಲ್ ಲೀಡ್ ಕಾಪಿ ಕೋರ್ಟಲ್ಲಿ ಇದಾವೆಲ್ಲ.
ಕೋರ್ಟಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿ ಇಶ್ಯೂನೇ ಮಾಡಿಲ್ಲ. ಕ್ವಶನ್ ಆಫ್ ಲಾನೇ ಫ್ರೇಮ್ ಮಾಡ್ದಂಗೆ ಲಾಸ್ಟ್ಗೆ ಅವರೇ ಹೆಂಗ್ ಬೇಕು ಹಂಗೆ ಬರ್ಕೊಂಡಾರೆ. ರೈಸಸ್ ಇನ್ ದ ಅಪೀಲ್ಸ್. ಉಳಿದಿದ್ದ ಅರ್ಧ ಪೊಸಿಷನ್ ಅವರು ಪೊಸಿಷನ್ ಇದಾರ? ಏನಿಲ್ಲ. ನೀವು ಪೊಸಿಷನ್ ಇದ್ದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟು? ಟ್ಯಾಕ್ಸ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ರಾ? ಅವ್ರೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಮತ್ತೆ ರೆಗ್ಯುಲರ್ ಪಿಲ್ಲಲ್ಲಿ ಯಾಕೆ ಚೇಂಜ್ ಮಾಡಿದ್ರು? When the facts the client to have the instrument decree cancelled citizen.
ಇದೊಂದು ಆಗಿ ಕೊಡ್ಸೋಕ್ಕಾಗಲಿ ಲೇಟ್ ಆಗ್ಬಿಟ್ಟು ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ
ಒರಿಜಿನಲ್ ಇದು ಲ್ಯಾಮಿನೇಟ್ ಮಾಡಬಾರ್ದು. ಹಾ
ನಂದ್ರು ಅಶೋಕ್ ತೆಗಿಬೋದಾ ಈಗ?
ಆಟೇನೆಲ್ಲ ಹಾಕಿ ಇನ್ನೊಂದು ತಗೊಳ್ಳಿ. ಹಾ
ನಂದ್ರು ಅಶೋಕ್ ತೆಗಿಬೋದಾ ಈಗ?
ಆಟೇನೆಲ್ಲ ಹಾಕಿ ಇನ್ನೊಂದು ತಗೊಳ್ಳಿ.
ಇನ್ನೊಂದು ಕಾಪಿ